Lordship, I beg to mention item number 7.
Admission.
Yes, Your Lordship.
No. Admission and order matters. Please mention when the item reaches. Only hearing matters. If you want to adjourn, you adjourn now. Okay. If it's hearing, then you mention. Yeah. Otherwise, other
It's an orders.
orders. Just wait. Let the item reach. Yes.
Before coming to
This-
the
this-
Lordship, project impel order. Lordship, there's a close of land, Lordship. Huge close of it, around 26,000 square meter. Lordship.
Okay.
And on that very plot, Lordship, there was a dispute between the present respondent and one Mania. And ultimately that was litigated in
Okay.
title suit number 19 of 2017 laws.
Another case.
Another case. And this is the Lordship, this is the Lordship,
Title
between
suit 19 of.
of 2017. Then between Tavataka versus Mania.
That means the present respondent and
And
another person. Okay.
And this is for an amount of 26,888.300.
Situated at Model Village.
This Mania, who lost the Lordship, title suit, they appealed before this session court, appealed before this court. He went up to the Honorable Supreme Court, and he lost there also. So meaning there was this lawsuit decree with remains between the petitioner, present respondent and Mania.
So finally, after going till the Supreme Court, it's in favor of this Tabataka. This one.
Tavataka, present respondent lawsuit.
Okay.
Now lawsuit, what happened? When this title suit was filed, I was not made as a part. Whereas lawsuit, a portion out of this very lane lawsuit, area of 980 square meter, it was only sold to me in 2014 itself. Lawsuit.
When?
2014. If lawsuit turned to page 15 of my present division section lawsuit. This is dated 8 September 2014 lawsuit. By this sale deed lawsuit, area is mentioned at third paragraph lawsuit, 980 square meters. It was sold to me by the present respondent.
On 8 September 2014.
2014 lawsuit.
And this title suit was 2017.
17 lawsuit. And I was not made party in that suit. And I was not aware lawsuit about it. Now, in the meantime, what happened was in 2023 lawsuit, the petitioner sold this plot to another 2 persons lawsuit.
This same plot.
This not 20
same plot
all
which
the
was
these
sold-
are yes 980, which I have purchased from the present respondent. Then lawsuit, I lodged complaint before the Gambura. Gambura is the village authority recognized under the lawsuit Assam Territorial Regulation 1945. Here they have been given unlimited power to decide a civil dispute lawsuit
Acha.
in our state.
Okay.
This
Gambura.
parallelly lawsuit, it can be lawsuit. One can approach the civil court also, and at the same time they can approach the village authority also. Parallelly, one can approach lawsuit. Now lawsuit, what happened? The village authority kindly come to at page 20. I complained lodged before the lawsuit village authority, and accordingly this was decided by the village authority. And the operating portion lawsuit, I would like to read the bottom lawsuit, the last paragraph at page 20. Therefore, power conferred under section so and so, Assam Frontier so and so, I, Sri Techi Murthy, head Gampura Model Blaze, Nahalang do hereby pass this order against Sri Taba Thakur to refund back the said amount of rupees so and so, along with interest as per bank norms, or to give position of the said land measuring 980 square meter situated at Model Blaze near helipad within 1 month today. Also,
So
this-
it was passed in your favor.
It's passed in my favor. Lordship, this was Lordship passed without, because notice was served to the respondent. He didn't appear Lordship. Therefore, a revision petition was prepared before this court Lordship. As per our Civil Courts Act Amendment 2023 Lordship.
Mm.
To pass ex parte order, at least 3 times notice has to be served, even if he has received the past notice also Lordship. That is dear Lord. On that count Lordship, at page 22.
22, yes.
This is the Lordship civil revision petition filed by the present respondent before this honorable court. The contention was that Lordship, he was not given opportunity of,
Against that Gampura's order.
against a Gambura order Lordship by the present respondent approached before this honorable court by contending that Lordship, he was not given 3 times opportunity
Mm,
as per the Lordship Civil Courts Act. Lordship. Accordingly, this honorable court allowed the revision petition. I would like to read Lordship second paragraph from in page 25, page 25 Lordship. After hearing the learned counsel for the party, this court is of the opinion that the petition deserves to be given an opportunity of contesting before the head Gambura. Therefore, the impugned ex parte order so and so passed by the head Gambura, Model Blaze Nahalang are set aside. The case is remanded to the Blaze Gambura for deciding a case after hearing both the party sides. It is further directed that parties to the dispute before the Blaze Gambura shall maintain its status quo in respect of the suit land. It is also clarified that no construction work should be done and no third party rights shall be created in respect of said suit land without permissions of the Blaze Gambura. It is further directed that the Blaze Gambura shall decide matter within a period of 3 months from the receipt of certified copy of this order. This is the Lordship direction given to the Blaze authority to decide a case after hearing the parties Lordship. Then come to page 27 Lordship. All this happened after Lordship decree has been passed in that title suit 19 of 2017 Lordship. It was passed in 24 February 2023
24th February.
Lordship. This development, the litigation comes after this very Lordship title suit. Now, in this press decision Lordship, what the Gambura Blaze authority has decided that operating portion Lordship is at page 30 Lordship.
30,
Page 3030.
30.
3030. And I'm taking Lordship to the last paragraph, bottom. After considering all the evidences given by both the parties and witnesses, and after considering the documents produced before me, I am of the considered view that Sri Taba Thakur shall give a land measuring an area of 9 square meters to Srimati Lagang Dumi from his land area situated in the same location near helipad and under model Blaze area S, because the this land has already been sold to Srimati Yonter Gai and Karba Ngondi, and they have already constructed their house and boundary wall. If Sri Taba Thakur does not want to give land measuring so and so in the same locality, he shall repay the sale price of rupees so and so along with interest of 4% per annum as per prevailing bank interest rate, which comes to rupees so and so within a period of 1 month from the date of this judgment. Further, considering the above mentioned direction, I do hereby vacate my order dated so and so, pass in compliance of the Honorable Court order dated so and so and so and so. This is the decision Lordship.
This is after hearing both parties.
Yes, after hearing both the parties. Now, Lordship, by this order, some changes has been brought, Lordship. One lawsuit, the suit lane has been already sold to the third party lawsuit. So therefore, that may not be disturbed. But the respondent, the respondent has to either return me the sale price along with the interest at the bank rate, or to give me an alternative plot within the same area lawsuit. That is the direction. Against this order lawsuit, the present respondent filed an appeal before the civil judge, senior division, UPL lawsuit, who passed the decree earlier lawsuit in title suit number 19
In
of
this-
17 lawsuit. This is the appellate lawsuit forum. Now, if very interestingly lawsuit, kindly come to page 34 lawsuit. Their title appeal was filed. This is the filing sheet lawsuit taken out from the lawsuit. Filing date 13/12/2024 at serial number third column lawsuit. Appeal number 9 of 2024. Registration so and so and so. First hearing was done on 12/3/2025. Next hearing is 14/5/2025. 14 May lawsuit. It was supposed to be heard on because on 12 lawsuit, 12 March, notice has been issued. We were not there lawsuit. Notice was issued, and because it was a past hearing lawsuit, then matter has been fixed on 14 May, which is yet to come lawsuit.
Yet to come.
Now, very interestingly lawsuit, at page 36 lawsuit. This is the course list of dated 21st March 2025. 25 March
21st
2025.
March.
At serial number 10 lawsuit. Title appeal number 9 of 2024.
So it was listed on 21st March.
25. What is it? It is supposed to be listed on lawsuit 14th of May.
14th of
May. And all of sudden lawsuit, within lawsuit 8 days lawsuit, this very title appeal has been listed on 21st March, last month itself. And first the impugn order. Impugn order is at lawsuit page 32. Page 32.
32.
Why I took lawsuit to the coast list, that's very pertinent. While lawsuit examining the impugn order itself. Lawsuit, this impugn order is in IA number 20 of 25. Lawsuit might have seen one. Entitled appeal number so and so. What happened in this case lawsuit? Appeal has been filed. One IA is there lawsuit for stay of the action. A press IA also has been filed by the present respondent for stay of the lawsuit. The order judgment passed by the village authority. Lawsuit have seen the coast list lawsuit. This IA has not been listed on that day. IA has not been listed lawsuit. But on the same day lawsuit, IA has been taken up, and without giving us opportunity lawsuit, stay has been granted. This is the past lawsuit, my grievances before this court. At least I should have been heard lawsuit. Now on what count lawsuit, this lawsuit stay has been granted, that I'll take lawsuit to. Case, I'll read the lawsuit in order. Case record is put up in view of IA number so and so, filed applicant oblique appellant. Learned counsel so and so, Modi present. Learned counsel D. Riva has filed Bakalanama to represent respondent both in title so and so is so and so. Learned counsel for the appellant is directed to serve copy of appeal memo filed to the learned counsel for the appellant today itself. Learned counsel for the applicant oblique appellant has filed IA number so and so. Rule so and so 151 CPC. Praying for stay of execution proceeding being execution suit number 7 pending before Extra Assistant Commissioner Nahalagar. It is aware that in the application that the applicant filed a title suit before the Court of Civil Judge Senior Division entitled suit number 19 that judgment was. Whereby degree dated so and so was passed in favor of the applicant, affirming title of suit lent to him. Subsequently, the said judgment and decree was upheld before the Honorable District Judge UPA, the Honorable Guwahati High Court, and affirmed by the Honorable Supreme Court. Thereafter, respondent filed a complaint before Gambura of Model Blaze concerning plot of land measuring 980 square meters. Subsequently, Gambura passed impugn order judgment so and so, which is challenged in the main title appeal 19/2024. It is also aware here that subsequent to passing of said judgment and order dated so and so by the Gambura Model Blaze Nahalagan, one execution proceeding by execution application number so and so has been initiated before Extra Assistant Commissioner, and in connection notice has been issued by the EAC Nahalagan to the applicant. It is submitted by the learned counsel for appellant that the said plot of land measuring 980 square meters is part of the suit land, the title which was decreed in favor of the appellant in the title suit number 19 of 2017. Learned counsel for the learned counsel for the represent has submitted there is no urgency in education proceeding pending before so and so Nahalagan, as applicants are yet to file so and so. Her board the counsel seen the record, considering that the Court of Civil Judge Senior Division UPA, while deciding the title suit number 19 of 2017, passed decree in favor of applicant and granted title interest in his favor to the suit land, and the same were upheld before the Honorable District Judge UPA, the Honorable Guwahati High Court, and affirmed by the Honorable Supreme Court. And despite that, it's very important, despite that, Gambura Model Blaze Nahalagan passed the order dated so and so in connection to disputed land of 980 square meters, part of suit land entitled suit number 19 of 17, and considering that in connection related execution petition number so and so is filed before the EAC Nahalagan and related notice is issued by the EAC Nahalagan, this court is of considered opinion that the sufficient cause is made out to grant stay on the order dated so and so passed by the head Gambura Model Blaze Nahalagan till pendency of the instant appeal under so and so and so and so. This is a lawsuit mine of the learned court below, on which lawsuit interim order has been passed, and the judgment passed by the Blaze authority has been stayed lawsuit. Now, past question lawsuit. While staying there's a Honorable Supreme Court, the recent judgment also, March month lawsuit. Education has to be completed within lawsuit period of 6 months. Else lawsuit, the judicial official is answerable
Officer
to the
will be
House.
answerable, yes.
Here lawsuit, at least opportunity of hearing should have been given to us. This is a duty cast upon the Honorable the learned court below lawsuit. While staying the lawsuit, the order passed by the Blaze authority. On the very first day lawsuit, the matter has been disposed of without hearing us lawsuit. Secondly, lawsuit has seen the
But-
mind.
21/3/25, it says heard both learned counsels.
Yeah. Because appeal has been listed lawsuit. I have taken lawsuit to the coast list. In
Not-
connection to appeal
okay,
lawsuit,
okay, so IA was not listed.
not even listed lawsuit. Not even listed lawsuit. And even then lawsuit, on the same day, if the copy is served, then how lawsuit, one will lawsuit argue the case lawsuit.
Hmm.
What I'm submitting is lawsuit. This is the duty cast upon the learned court below to provide an opportunity of hearing in the form of written objection. At least 2-3 days for 1 week time should have been given lawsuit to us to file objection. Even if we have not prayed also lawsuit, that the duty is upon the lawsuit below lawsuit. Then secondly lawsuit, what is the mind behind passing this impugn order lawsuit? The principle of res judicata. The learned court below says lawsuit, over this suit land, already this court has decided decree in favor of the president.
Yes, referring to this.
Yes. And it has been affirmed by this court, then up to Honorable Supreme Court. If I take lawsuit to the section 11 of the CPC, the principle of res judicata is only applicable the same subject
Between the
matter
same
between
party?
the same parties lawsuit. On the very base lawsuit, on sole ground, that is sole ground, the principle of res judicata has been applied, which is on face is not applicable in the present case lawsuit.
Respondent is represented.
Therefore, what I'm
Yes.
saying, Lordship, my prayer is that, Lordship, this impugn order may be set aside and matter may be
May be
remanded
heard.
back. Hear us, April within 2-3 days, no issue, Lordship.
You,
We
do
do
you
not
have any
prejudice the
objection
other
to
party
that?
also, Lordship.
Yeah.
That's all, Lordship.
Because, okay, I'll hear you. Yes. Yes. We are on the impugn order 21-3. Yes.
Decree in favor of the applicant and granted by the title interest in his favor to the suit land and same will upheld before the district judge UPA, the Honorable High Court, and affirmed by the Honorable Supreme Court, and despite the head Gawra Model Place Naharlagan passed the order dated 14/11/2024 in connection with disputed land of 900 square meters. And considering that in connection related, the execution applications number 4, 2025 is filed before EAC Naharlagan and related notice is issued by EAC Naharlagan. This court is considered opinion that sufficient was made out to grant stay on the order dated 14/11/2024 passed by the head Gawra Model Village Naharlagan. Till the my lord Mekanly noted that till the pendency of instant appeal. This order was passed. It's the only till the pendency of appeal. My lord, that means this order is a interlocutory order. Interlocutory order. So my lord, after amendment of 1999 amendment of CPC.
So you're saying revision will not lie against interlocutory order?
My lord, after 1919 amendment of the CPC, interlocutory order cannot be filed under, it cannot be maintainable under 115 of the CPC. My lord, may refer the 115 of CPC.
Yes.
Given question. My lord, here the second provision. Second provision. Provided that the High Court shall not, under this section, vary or reverse any order made or any order deciding an issue in course of the suit or other proceeding, except where there is order, if had been made in favor of party applying for division, would have finally disposed of the suit or other proceeding. This is that this impugn order is interlocutory order. Therefore, the civil division under 115 shall be maintainable. Therefore, this division is not maintainable. In this support, my lord, one judgment passed by the Honorable Supreme Court. Kindly see the paragraph 6. Leave it.
Yes.
We are constant to observe that every legal canon has been thrown to the wind by the impugn judgment. First and foremost, the 1999 amendment to the CPC added the provision, section 115, which read as follows. The High Court may call for record of any case which has been decided by any court subordinate to such High Court and in which no appeal lies therefore, and if such court subordinate court appears, A, to have exercised jurisdiction not vested in it by law, to have failed to exercise the jurisdiction so vested, C, to have acted in exercise of the jurisdiction illegally or with material irregularity, the High Court may make such order in case it think fit, provided that the High Court shall not, under this section, vary, reverse an order made or any order deciding a issue in course of suit or other proceeding, except where the order, if had not been made in favor of the party applying for revision, would have finally disposed of the suit or the other proceedings. 3. A revision shall not offer a stay of suit or other proceeding before the court, except where such suit or other proceeding is stayed by the High Court. Now, the relevant point is here. A reading of this provision will show that after 1999 amendment, revision petition filed under section 115 of CPC are not maintainable against the interlocutory order. Now, since the order being challenged by the petitioner is a interlocutory order, therefore this petition is not maintainable.
Dependency of the instant appeal. No, but the question is if a case has been listed or taken up when it is not listed. So that is the question again.
Madam,
So,
I am arguing on the
Yeah.
validity of the petition,
okay, okay.
not
That is
in
also-
merit, because I have received the copy just now.
just now.
So I'm only arguing on the maintenance of the this petition. This petition itself is not.
Then in that
maintainable.
case, we will just issue notice and then if you like to file a objection, written objection.
Madam, since
Short
I
time.
I have objecting the maintenance of
Yeah,
the.
you'll come on that also.
uh, So that maybe
Short
I will
date.
file my objection.
Yes, short date. And records will be required.
Lawsuit, also can you see? You know what it says lawsuit? The section one.
No, against interlocutory order revision does not like that, so it's a known
What?
fact.
What one
But-
five says lawsuit,
Hmm.
the provision. It says
No,
lawsuit.
we'll examine later. For today, let's issue notice.
It has been disposed of lawsuit. IA has been disposed of lawsuit.
My lord, since this
Because
Petition is-
No,
IA
but it is a stay order. It is a stay order.
No, what it says, kindly
The order is a stay order, interim order, which only says
in the
that
pendency of
till
appeal.
dependency of the
Appeal on-
appeal.
stay order is
Hmm.
based on the introductory order only. And this stay order has been considered under lawsuit, the rule put here on clause 5 lawsuit. And that is IA has been filed lawsuit. It's not that the IA is pending lawsuit. If IA has been pending lawsuit,
Accordingly, prayer in the IA such and such,
IA has been
paper partially allowed, IA is disposed of on contest. Yes, yes.
But
if IA is pending lawsuit, I can
Yes,
understand lawsuit.
yes.
But IA is disposed of 115 language is what it says. lawsuit.
IA is disposed of.
my lord, this order is a interlocutory order.
No, but you see the last para.
My lord, though I
Accordingly, prayer in such and such is hereby partially allowed. IA 2025 is disposed of.
yes, my
on
I
contest.
however this order is
It's already disposed of.
this order is a interlocutory order. It is come under the
No, no, no,
Confusing with
no, no, no,
lawsuit.
it is not. It is
If
not.
lawsuit see the section 115 law, it makes a
It
very
is
clear
not.
law.
and my lord.
Regarding that,
We will dispose of. Remand it back.
My lord, because they have filed one execution petition
Mm.
before the ES in Parliament. If
That is a different thing. That's a different issue. That's a different issue in connection with this title suit 19 of 17. We're
no, my
disposing.
lord, in connection.
No, if you have objection, I'm disposing of remanding it back. That is my, I'm just expressing the court's mind. But if you want to file something, you can file.
My lord, it is,
It can come up before another court.
I have objecting the maintenance of the.
No, that's why if you want to object,
I
you
may
file.
be- I may be allowed to file. Objection.
Okay.
If they only want delay the better law.
No,
No, we'll give a short
If
time.
lawsuit see the 115 laws, what it says lawsuit?
No, this court has
115
already
is okay.
expressed the mind of the court. So
What lawsuit express, to me, I think it's not going to prejudice
But-
the other party.
My lord, it will,
we have to give them an opportunity, na? So let them file.
Delay
But
lawsuit,
1
delay
week,
the-
1 week,
Yeah.
you can file it in 1 week. Third General Counsel for the petitioner. Sri such and such. Learned counsel has stated that the impugn order in the present case is an order dated 21/3/2025, passed by the Learned Civil Judge, Senior Division UPR in IA number 20 of 2025, arising out of Title Appeal 9 of 2024. I'll just say issue notice. However, since the
My lord,
Learned Counsel for the sole respondent has already entered appearance, you have filed your Vakla Nama.
yes, all the time. This is the, I am objecting the materiality, so notice maybe not issue, because I only file only objection on the materiality of the.
Okay, then forget about the notice. But since Learned Counsel such and such has entered appearance for the sole respondent, no formal notice is called for. The Learned Counsel for the respondent is allowed to file his objections
Regarding the materiality.
regarding the maintainability and any other ground, if so advised, within a period of 1 week.
Maybe listen on 8.
List
Ninth.
the matter on 9th. 9th or 10th, 10th of April.
Maybe more than I think.
10th of April. It will be just 2-3 paragraphs
Because my lord, I have already fixed, so many matters in line. so
on 9th.
On 10.
Okay, 10th April.
One day doesn't.
Yeah.
May I please, ma'am.
Yes.
My lord, in this case, I was arrested on 10/1/2025. On the strength of the FIR dated 10/1/2025, if I may take my lord to page number 16, 16, ma'am.
Yes. Arrested on
Arrest memo is at page number 21, ma'am. On the same day I was arrested,
page
21. Date, time, place of arrest, 10/1/2025.
10/1/2025. Okay, so
Therefore, my lord, at this stage, I won't be going into the facts of the case, my lord. CD may be called for. I've been under custody since last 83
PP.
days. Next Monday, my lord, was
where did you get it?
Roymuk PS is very nearby.
PP
We eat on lordship 9 or 10.
9th.
9 or 10.
This is a bail, this is a bail application, 9th.
Right.
Bail application, on behalf of the accused slash applicant. What's the name of the, Dhan
Dan
Sharma,
Sharma.
Shri Dhan Sharma. PP has, Learned PP has accepted notice for the state respondents. List the matter on 9th April, on which date the Learned PP shall obtain scanned copy of the updated case diary.
Item number 3.
The bail application filed under 483 of the NSS. In
Excuse me?
connection with SEPA PS case.
Hmm.
Here, your lordship, this accused person was arrested on 17th of March. And he's practically for since last 18 days. And the incident took place on 11th of March. Because an FIR was filed a loss after 6 days after the arrest, incident.
PP
So in
obtained
meantime, CD may be called your lordships.
So he's straightly directly come before the honorable court, your lordship. Otherwise, it is permissible. However, your lordship, they may
Oh.
refer before the
Sessions.
trial court first. Yes, your lordship.
No, your lordship,
What happened?
the session court we have approached, still session court SEPA is not functional.
Not
In-
functional.
Not functional.
Yes,
So
I
many
was
cases are
wondering why,
directly. I mentioned in my.
why is
paragraph.
it not functioning?
So most of the case, we are compelled to approach before this honorable.
No,
court
no, no.
because
What is the reason? Why is it not functioning?
already
Because
said-
that is a very
still,
serious issue.
Not shifted and building construction is still going on, so It is not been functional. In other bail application also in regard to SEPA PS case, if we have filed before this honorable court with no other alternative, your lordship.
The Learned District and Session Judge Sepa, is he looking after other districts also?
Yes, your lordship, now
That
the
because-
district and session judge SEPA is not take up in the, your lordship, the case. So we have no other alternative, your lordship.
In that case, your lordship may direct the concerned court to take up the matter, your lordship. But it's a very serious allegation against the session judge because session judge is posted there.
Exactly, that's why if this comes to the notice of the High Court, na,
Yes.
administrative side, he will be in trouble. The Learned
Yes,
Session
lordship,
Judge
we
will be in
have, when
trouble.
they are in, we have, where
I'm-
we have filed by, we have.
Just because the building is not completed doesn't mean that the court will not function. It must be functioning from somewhere, from another district
No,
also.
lordship, earlier also in similar case from SEPA,
Hmm.
in those cases, this honorable court have taken up the matter because of non-functional of session court.
Because if I note in my order saying that because this court is not functioning, the High Court is taking it up, then it will have serious impact on the Learned District Judge.
I pray that your lordship,
You-
time CD may be.
you
called,
withdraw? You withdraw and file before the,
With your lordship, with the direction to the learned court from this court,
Yes,
if
yes.
they approach this court, the matter may taken up, your lordship. Otherwise,
yes.
again, they, every time they will come with that ground, then.
Yes,
it is not
every
taken up
time,
the matter.
so many other, it will just set a precedent and others may also come saying the court is not functioning.
We are
Then
also
finally-
following some precedent of other cases in connection with the SEPA case. Earlier also, this thing had errors as your lordship, and this court had taken up because SEPA is far away from here, 5 hours journey, your lordship. We went there, your lordship, but they have refused the non-functioning of district and session court. We were compelled with no other alternative to approach before this honorable court. Your lordship, I pray that for the interest of justice, your lordship.
This we have to first set it. Nothing.
Lordship, then instruction may be taken, because your lordship, this is not only concerned with this bail, because
There will be many other cases before this court. So what do the litigants do?
Again, your lordship, from here, again, we'll go there, when they have don't take up, or the judge is not there, it will be,
No.
it's very hard.
We
your
will just leave this, let this matter come up next week. Okay, and then in the meantime, you also get some instructions and we will also make some inquiries. Okay,
Whether,
yeah,
yes,
yeah,
yes,
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 yes.
your lordship. And your lordship,
Let it come up
it's on next week, your lordship,
next week. Yes.
Monday, 7.
Let it come up on 7, this court is not sitting, so 8,
6.
8.
Okay.
nice.
Malone has dealt this FIR number yesterday in a unlisted matter.
Oh, those,
Yeah.
that's
Malone here,
series of.
yes,
We
But
have called for
here-
the case study. Lord.
Yes.
Malone here,
I think. we can
petitioner
work
is
the
a
same.
generic.
Here also, what is your alibi?
Alibi, yes.
One had kidney problem, one was in Itanagar refueling
He was
somewhere.
during that time at
Yes,
Itanagar.
so where were you?
Mine is, Malone, I'm a junior engineer. I was very much here in Itanagar, discharging my duty.
Finally, no one will be there. So I
No,
think
madam.
if they were ghost.
Yes, but second thing is that although my name is figured in the subject, but no whisper has been made against me in the content of the FIR. Wow. Number 2, Malone.
No, against the others also, there's
yes.
nothing.
Nothing.
They just say that these people were there at that
Correct.
spot.
That's, I am very much here. My lord will kindly come to page 22. All the officials were here in this hotel, Malone, and I checked out on 29th. And I have made a categorical statement, Malone. There is a
Page
CCTV.
22.
Not 22, Malone, this is a hotel bill. I checked out on 29, Malone.
Your name is this Tagru.
Yes, yes. Tagore.
So booking, check-in date 16th March, check-out date 29 March.
And to fortify my argument, Malone, kindly come to page 28.
This is official order. Manor will see this on 01/04/2025. Submission here with absentee statement for the month of March 25 for regular staffs of staff division establishment for period mentioned above.
So where's
Name and
your name?
designations. I appear
Serial
serial number
number?
3,
Three.
full month present below.
Submission of absentee statement for the month of. No staff submitting.
And this is because, Milord, because of page number 21. No, full present tense. This office is witnessing, Milord, first March order. This office is witnessing many complaints from BVIPs for not getting regular and sufficient water supply in respective government allotment bungalows. Hence, all junior engineers of this subdivision, Itanagar, are directed to keep vigilance and ensure proper water supply to the consumers. And further, it is informed that no casual or earned leave will be expected till 31st March. I have not gone, Milord.
Okay, we have passed orders yesterday, so similar order was,
Yes, sir.
this application under section 482 of the BNSS has been prayed for granting of pre-arrest bail to the present accused slash applicant in connection with the Palin Police Station case number 8 of 25, registered under section 109 under bracket 1/118 under bracket 2/3/5 under bracket of BNS 2023, read with section 27(1) of Arms Act. Stop. I have heard learned counsel Mr. T.T. Tara appearing for the applicant slash alleged accused. And it is stated that the petitioner slash the applicant slash alleged accused was not at the spot of the incident on 26. What was the date of the incident? On 26/3. On 26/3/2025. And he has drawn the attention of the court to Annexure 3 of the application, wherein it is shown that the petitioner was in Itanagar and putting up at Hotel Todo, TODO. And the annexure shows that the check-in date was on 16th March 2025, and he has checked out from the said hotel on 29th March 2025. The learned counsel for the petitioner has also submitted that there is an office order of 1st March 2025, which is at annexure 2 of the petition, wherein it has been directed that all the junior engineers of the subdivision Itanagar are directed to keep vigilant and further not to avail of any casual or earned leave till 31st March 2025. Stop. It is stated that the petitioner, being a junior engineer, has not left Itanagar during this period, and hence the present petition praying for pre-arrest bail on the ground that the petitioner slash alleged accused was never at the scene of the alleged incident on 26/3/2025. Stop. Learned PP L. Hage accept notice on behalf of the state respondents. List the matter on, we can list it together, no? On 9th of April.
Ninth, my lord, I have some difficulty on ninth.
But
Right.
Lordship, we have.
Other
more
similar
on-
matters
Yes,
are
Lord.
fixed on
Correct.
9th.
Yes, Lord.
Your junior can appear.
Yes, Lord. Anyone can,
Correct.
appear. Only
Anyone
case,
can
case
appear
very
because it will be
difficult.
covered only.
Yes, Lord.
It will be the same order in all the cases. List the matter on 9th along with other similar cases arising out of the same case. And the learned PP shall obtain scanned copy of
Yes.
case diary, updated case diary. So, in the interim, it is directed that the petitioner slash alleged accused shall appear before the IO and get his statement recorded within a period of 3 days from the date of this order. Stop. Number 2, in the event of arrest, the petitioner slash alleged accused shall be released on executing or released on bail on execution of bail bond of rupees 30,000 to the satisfaction of the arresting authority. So it is made clear that this interim order shall be subject to the outcome of the final hearing on 9th April 2025.
I'm much grateful.
Lordship, in the similar matter also, they have directed to appear before the IO, Lordship.
Yeah.
Lordship. Much obliged.
Since all the process has been completed in this case,
Process
Yes.
complete.
can this matter be posted for hearing? Well?
But respondents are not represented now today. Learned counsel for the appellant. Or not appellant.
For the,
For the petitioner, J. Chiring is present. None appears for the respondents on call. However, the office note indicates that notice is complete in respect of all the respondents. How many respondents?
altogether, my lord,
1 to 6.
6.
But notice is complete on all the respondents, no? Accordingly, the matter may be listed for hearing. In usual course,
Is of course.
for hearing in usual course.
Yeah, well, Lordship.
Yes.
But appeal has already been admitted, the matter has been listed in
Admitted.
admission. It is admitted, if your Lordship kindly turn to order dated 19/12/2024 in the appeal matter.
In the appeal or IA?
No, appeal. There are two IA matter. I'll come to IA later, matter. Your Lordship will kindly take the appeal. Appeal number, LA appeal number 2 of 2024,
Order dated
19/12/2024.
1912, okay. Present application has been. As all respondents are represented, no formal notice is required. However, requested copies and admit the appeal.
Admit the appeal. matter.
So, the reference case also has come.
I mean,
DTR.
that has come, but your Lordship, on the last occasion, direction was given, if your Lordship kindly turn to order dated 3/3/2025. Last order,
Yes.
my lord, I'll come to the next page, second page. Considering the submissions made by the learned counsel, for both the sides, I'm considering the fact that original reports are not made available. I hereby direct the respondent number 72, the Deputy Commissioner, Yomi District, to produce the original records in the next date, listing the parties, also liberty to peruse the records. So far, the reference records are already arrived on the last occasion,
Oh,
and the original records of the Deputy Commissioner,
From the deputy commissioner.
those were not available. So, my lord, I have been told some reports have come, but we have not been able to check whether all the records have come or not.
Learned additional AG can apply.
We have not received any communication from the.
From the DC.
Yes.
I believe one file,
Here, office order dated 25/3 states that original records of office file number such and such has been received from Office of the Deputy Commissioner, Yomi District, Dato.
That had come directly to the registry, I
Or
believe.
maybe, yes, yes. It must have
Directly to
come
the
there.
registry, not through the council.
Yeah. Then you will certainly require some time. Just, yeah, let them peruse the records. We can fix it another day then. The main epi-
Lordship can not fix the matter on 7th of May, and it is, my other friend.
7th of May.
7th of May. In the meantime, they will go through the record, but the reports are voluminous.
Voluminous,
What
yes.
I am proposing before my lord, that we will apply for the certified copy. And we can,
That's better. I
so
think.
unless it's because sitting here and going.
Going through that is,
That's
that
not
is
possible.
not
And
possible.
we are also coming from Guwahati, so
Mhm.
it's not possible to go through and all.
You apply, yes, you
And if
apply.
your lordship permits that we'll apply for certified copy, office will, give the certified copy of the.
That's possible, no? Maybe. They can apply for CTC or
Ah,
then the office will supply.
Public record.
But of course, it is really
They will photo state it.
photocopy.
We'll pay for it, madam. It's not that free of, not required free of cost. We'll apply for certified copies accordingly.
Possible, na? Let them apply for CTC.
They will take little time.
Yes.
May not be possible in 1 or 2
It will
days.
take, it will take time.
Our local councils are here, they will correct it.
Learned councils for the parties are present. The original records of office file number LM-33/2010 and LM-33/2010 under bracket PT has been received from the Office of the Deputy Commissioner, Yomi District, Dato, Arunachal Pradesh, as directed by this court on 3/3/2025. Stop. However, it appears that the records have been sent to the registry and not through the additional advocate general. Stop. It is bid by the learned councils that they may be allowed to obtain certified true copies of the records as they are voluminous and it will not be possible to peruse the records in the registry. Stop. Accordingly, the learned councils may apply for certified true copies of the records, and the same will be furnished by the registry. Thereafter, the matter may be listed on, you were saying 7th March. 7th May. Thereafter, matter may be listed on 7th May 2025, registry to do the needful on receipt of the applications.
So far, the other two miscases are there. They are not, let come up along with that, not required. Any order, no order.
IA 252 of 2024 and IA 12 of 2025. Let it come up along with the main case on 7th May.
Deputy.
My lord, they are supposed to file affidavit, your lordship, additional affidavit in to bring into record the,
Petitioner was
yes, your lordship. Let,
additional affidavit. You
Yes,
filed
we have not filed. We will file within this week.
within a week. Learned counsel for the petitioner is yet to file the additional affidavit and prays for 1 week's time to file the same. So prayer is allowed, at least a matter after 1 week. In the meantime, the learned counsel shall file the additional affidavit.
There is an interim.
The interim order passed earlier shall continue till the next date.
oblige.
Ex parte. Proceeding. Sole explanation occurring in this case.
Service is complete in respect of sole respondent. No Bakala Kama filed on behalf of the service.
Madam, this mechanism is full of dead. They are not. My lord, hearing in this case, my lord, there was a link between the petitioner and the respondent. So respondent.
1 minute, okay. You've order dated 6/12, nah? 6/12/2024. Okay, what is your case?
My lord, there is a link between the petitioner and the respondent. Accordingly, the yes authority pass a judgment in favor of the petitioner. Accordingly, the respondent filed an appeal before the civil senior division, and matter was still pending. After that, due to the pendency of the appeal, one IA was filed. So
IA for what?
IA under order 41 rule 20 of CPC. And therefore, the petitioner is unable to file the objection.
You speak to the mic, nah? Cannot. Yeah,
Petitioner unable to file the objection. My lord, kindly see page number 34.
30?
34.
34.
Relevant paragraph, page number para 26.
1 minute. Para 26.
Para
Yes.
26.
The case will proceed
case
for
will-
hearing.
Proceed for hearing in the original appeal. The respondent is directed to file a reply objection on or before the next date.
Okay,
My lord, next date fixed on 19/12/2023. My lord, on that day, the counsel for the petitioner was not appeared due to some meeting regarding the bar association. And my lord, kindly see page number 44. This is the impugned order
44.
44. Merriman.
Yes.
To the fix for a reply and objections. Learned counsel for MS such and such for the appellant is present. Non-affair for the respondent. Learned counsel for the appellant submits that even after more than 1 year, the respondent has not filed his reply objection and as the period of limitation has already been closed. Prayer is made for not giving any further opportunity. Hard learned counsel and perusal of the record so that since 6/8/2022, the respondent have repeatedly sought time to file the reply, but even then they have failed to do so. It is also seen by order dated 4/2/2023 that the Court of Learned District Judge has categorically mentioned while granting some more time to the respondent to file their reply that the reply is to be filed within 1 month on or before of the civil judge. But even then, after passes of more than 9 months from the date of the said order, the respondent has failed to take step. For the reason aforesaid, the reply will no longer be accepted. My lord, here, why the respondent not filed objection? Because there was a IA pending before the civil judge. Therefore, and this order, my lord, order dated 20/11/2023, wherein my lord, next date for reply was fixed only on 19/12/2023.
Fixing 19/12/2023.
2023. And this impugned order
So
passed on
it's 19/12/2023.
2023. Only at least I have been given last opportunity to file reply. So my lord, here my limited prayer is that I may be allowed to file objection in appeal. That is my lord, my limited prayer.
Objection in the bis case.
Appeal, main appeal. I, my prayer, my lord.
Because here, this order at annexure 3 is IA order,
Yes,
IA
I order.
15 of 23. Then the impugn order is also in IA.
In IA.
Yes. So in IA only they are saying to file their objection.
Yes, I have been,
Directed to file the objection in
Yes.
the IA.
yes,
IA 15 of 23, which you did not file.
yes,
So now you are praying before this court to allow you to file reply objection in the
yes,
IA. isn't it?
yes, IA only,
IA,
objection
yes.
only.
Yes, then why you're saying main appeal? Because main appeal is civil appeal 68 of 23. That is different.
Well, I'm seeking, objection, to file objection in,
In
main
IA 15 of 23.
not appeal. IA has been already disposed. My lord, there is no separate order for IA and main case.
Oh, cha. On the same day they have
Yes.
passed the order.
Yes.
Right. This application under Article 227 of the Constitution of India has been filed by the present petitioner, praying for allowing him to file his objection / reply in the civil appeal number 68 of 23 before the Learned Civil Judge Senior Division, Pasikat. Stop. Learned Counsel O. Modi, na?
Yes.
Learned Counsel O. Modi appears for the petitioner and submits that the learned Civil Judge Senior Division at Pasikat by order dated 20/11/23
Madam.
had fixed the matter on 19/12/2023 for reply / objection, if any. Stop. It was also directed in the said order dated 20/11/23 that the case will proceed for hearing in the original appeal. Stop. And therefore, the present petitioner / respondent, your respondent there is
Yes, I understand.
/ respondent was directed to file his reply / objection on or before the next date. Stop. Thereafter, the matter was listed again on 19/12/23 as directed, and on the said date, the Learned Civil Judge Senior Division, Pasikat, directed that the reply of the petitioner, of the respondent / petitioner will be no longer accepted as there was inordinate delay on the part of the respondent to file his reply. And stop. And thereafter, the case was to proceed for final hearing, and it was fixed on 28/2/24 for final hearing without the reply / objection of the respondent / petitioner. Hence, the present petition under Article 227 of the Constitution of India. Stop. Learned counsel for the petitioner therefore prays that this petition may be allowed, and he may be allowed to file his objection / reply in the civil appeal 68, isn't it? Civil appeal 68 of 2023 before the Civil Judge Senior Division at Pasikat. Stop. Next para. service on the sole respondent has been completed. And this court, right order dated 6/12/2024, has observed that the notice has been duly served upon the sole respondent, and accordingly, service upon the respondent is complete. Stop. However, none appears for the respondent even today. Accordingly, this matter proceeds in the absence of the sole respondent. Stop. This court has perused the records available and also heard the learned counsel for the petitioner slash respondent. Stop. It is seen that the respondent slash petitioner had taken several, had made inordinate delay in filing his reply slash objection in the civil appeal 68/23. And therefore, the learned Civil Judge Senior Division Pasikat had proceeded to fix the case for final hearing without the reply slash objection of the present petitioner. Stop. However, it is felt that the reply slash objections of the present petitioner slash respondent would be required to adjudicate the case in the interest of justice. Stop. Accordingly, this petition is allowed. The learned Civil Judge Senior Division at Pasikat is directed to accept the reply slash objection of the respondent and thereafter fix another date for hearing of the civil appeal 2068/2023. Petitions disposed. That will do. I'm not quashing it, the thing. It's just that to allow your.
Yes.
Any other prayer?
No, no,
That will do.
only submission of objection.
No interim order was
Not-
there, no?
no interim. Plus,
At this point.
So the service is completed in respect of all the respondents.
Service complete.
Yes.
But they have not entered appearance, no?
The appearance is clear.
Serve notice upon respondent number 5. This court by order dated 12/12/2025 has observed that service is complete on all the respondents. Stop. Learned counsel for the petitioner appellant is present. Stop. However, none appears for the respondents. Even today, when the matter is called. Accordingly, please the matter after.
After 2 weeks, Lordship.
Let it be after 3 weeks. List the matter after 3 weeks, awaiting the appearance of the respondents.
Highly organized.
Here, Lordship, we, last occasion, we have directed to call for the case study, but here, Lordship, we have received the instruction that it is already been charge sheeted, Lordship.
Oh,
So, Lordship, record may be called for, Lordship.
the report from the court then.
Yes.
At the outset, learned PP L. Hage has stated that the matter is already charge sheeted and therefore the records may be called from the learned trial court.
Scan copy of the record.
Which court?
Lordship, what Lordship?
It would be
It may be session, Lordship. Session court, UPR, Lordship.
UPA.
Yes, Lordship.
So,
Basar, Lordship, sorry.
Basar.
Yes,
No.
Lordship.
What is 103
Lordship,
BNS?
Murder, Lordship.
Oh, now it has
please,
become
Lordship.
103.
Yes. BNS is
Still getting used to it.
Yes.
Okay, anyway, that the matter has been charge sheeted and the records may be called from the learned trial court. Na? Stop. Registry may registry is directed to call for the records of the case.
Scan copy of the trial court record, Lordship. Because this proceeding must be going on, Lordship. That's why scan copy.
We'll call
Okay.
for scan copy, but I'm just looking at the case number.
Lordship, may I submit you?
Yes.
Your Honor, in this particular case, Your Honor, alleged accused person is detained in custody for last 81 days. And at the time when this instant bail application was filed, Your Honor, it was not charged. It was on last 2 occasions, Your Honor.
No, but the court needs to look at the records, na. So whether it's the CD or the charge sheet, the court has to look into it before considering the bail application.
Your Honor, if we look into the last bail rejection order, Your Honor, there the court below, the session court, Basar has already stated that every statements and every investigation of the case has been completed, Your Honor.
No, that's why. So everything will be there in the charge sheet. Yes.
Now, Your Honor,
So we'll see.
the case is not at the
Because-
trial stage.
Because see, if it's a murder case.
Here, Your Honor, my concern is alleged accused person is languishing in the custody, Your Honor, for last 81 days. And if, as Anand PP has said, if the case is charged sheeted, then purpose of alleged accused person to be further detained in the custody, Your Honor, that is not required.
No. See, like murder case or NDPS, commercial quantity and all this, court usually is not inclined to grant the bail. No.
And Your Honor,
Unless-
in this case, there was no any deliberate murder as alleged, Your Honor.
Then how can we say now? Yeah. How
Here,
can-
Your Honor,
That is your statement
Still-
only. No, whatever it is, the court needs to look into the records. No, that is just your statement.
my concern is, Your Honor, when Leonard PP has said
We'll
that
give a short date. We'll give a short date. Maybe about 2 weeks.
2 days.
2 weeks, 2 weeks.
2 weeks, Your Honor, it will be too long. If short that could be given.
The Basar is how far? How?
Your Honor,
It is
Till-
far here. We'll, next week we can try, Lordship. If it's
We'll
not,
try
I'm
next week.
Lordship.
Okay. So what is the last line? What did I say? For the trial court records, in connection with Tomborijo
Tumporijo.
PS case number 1 of 2025 under section 103 within bracket 1 BNS from the court of Session Judge Basar. Just say scan copy of records, okay? Fix the matter on 10th.
10th of April.
Fix the matter on 10th April.
Lordship, the
Obliged.
direction can also be given to IO, since as per my knowledge, the case has not been charge sheeted in the court.
No, it clearly says that it's charge sheeted. This is from the IO.
Now, the case is not at the trial stage.
No, I know that, but when it has gone to the court, then the
Yes.
record will be in the court if it's charge sheeted. It will
And
no
Your Honor,
longer be with the IO.
Your Honor, there is one lacking that our upper supervisory has no own session court. Therefore, it goes to Basar, but before committal, it comes to the JMFC Dapurijam. So JMFC Dapurijam may be also directed here.
So just say Session Judge Basar / JMFC
Dapurijam, CGM Dapurijam,
or CGM,
Upper Subansiri District.
CGM Upper Subansiri District.
District, yes,
Mm.
because it comes to first
Okay,
CGM, then
okay.
after committal only it goes.
In another district.
Yes, in another district.
We take a chance, Lordship, whether it is there or it's got.
Yeah.
yes,
So
Lordship.
we'll just put Session Judge Basar /
That's it.
CGM.
Obliged, Lordship.
Obliged.
Lordship,
Yes.
this matter was taken up in the motion stage day before yesterday. That day, we prayed for calling of TCR, but however, our prayer has not been recorded in the order. Lordship, trial court record order. Yes,
Only
yes.
TCR, Your Lordship. Notice has been issued, only call for
Only for
DCN
the
copy,
TCR.
TCR.
Yes.
So in this, the other day, that order was
On first of
first of his, just right.
April.
On 1/4/2025, this court has already issued notice on the victim informant through the office of the PP. Stop. However, the trial court reports had not been called for. Accordingly, the registry is directed to call for the scanned copy of trial court reports from the court of
Longding.
court.
Longding. Yeah. Constant session court, Your
No, the
Lordship.
court of
Constant.
session.
Session court, constant.
Court constant. You're sure, no? Because here, Longding district, it says.
Yes, Your Lordship, it says in the Court of Special Judge POCSO, Konsa Session Division, Tirap District, Arunachal Pradesh.
Okay. Constant. Session judge constant. Yeah, and it is fixed already, no? It is fixed already. The date is given already.
Konsa, so it is.
That's order.
Session.
Yeah, 22/4. Is the matter on 22.
Konsa. Session.
In this matter, Lordship, CD, Lordship, we have received the case diary. And there is lots of objection, Lordship, here, because the alleged accused person is a pending cases in the different PS, Lordship. There's three pending cases,
Different
Lordship.
cases.
Yes, Lordship. The same case, Lordship, the same alleged accused, yesterday they have withdrawn the petition for the correction, Lordship.
Okay. I hope here they have not made that mistake. Application under section 482. Here also they have written BNS.
Yes, Lordship.
Anyway, petitioner is not there.
If not present.
None appears for the petitioner when the matter is called. List the matter next week.
Obliged, Lordship.
Perhaps Your Lordship, service is not completed. Question number 2.
No, notice is not complete.
Yes, Your Lordship.
Unserved notice returned back in respect of respondent number 2 with postal note insufficient address. Office note dated 19/2/2025 indicates that the notice on respondent number 2 has returned back unserved with the remark on the bracket, insufficient address not found, close brackets. Close inverted comma, stop. Learned counsel for the
Well, petitioner is absent, not present.
petitioner is not present on call. Learned PP, he is present. List the matter on receipt of notice on the respondent number 2, receipt of service of notice on respondent number 2. But if it's insufficient address, they may.
Your Lordship, they have to take
fresh
press steps actually.
Okay.
So Your Lordship, only since they are not appearing today, so this matter may be adjourned for at least for 2 weeks, so that when they appear, the court may direct them to take press steps, Your Lordship.
Okay, list the matter after 2 weeks.
Yes, Your Lordship. Deeply obliged.
May I? I respectfully seek an adjournment in this matter as the reading council is out of station.
Hmm.
So matter may be fixed after 3 weeks.
So that means after Bihu vacation, na?
Your Lordship, the service report is being awaited.
Service report. We. This is RSA, na?
Yes, Your Lordship.
So substantial questions already framed. And notice sent.
Actually, Your Lordship, I have not been,
You don't have the brief.
yeah.
Because in RSA, notice cannot go unless the substantial question of law is framed. Okay. First, substantial question of law has to be framed, then only notice has to go. Who's your senior?
Advocate D. Boje.
It is submitted on behalf of Learned Counsel D. Boje for the appellant that the counsel is out of station, and accordingly prayer is made for adjournment of the matter. This is the matter of the Bihu vacation.
Much obliged.
My Lordship, I'm sorry, Lordship, I was appearing in court number 1, Lordship. I'm from item number 12, Lordship.
In 12.
Lordship, here is some mistake in course title, so
Yes,
I
yes.
may be allowed to withdraw this
Withdraw and
application.
file afresh.
Lordship,
Item 12.
12, Lordship.
Petitioner is allowed to withdraw the application with liberty to file afresh.
Liberty may be given, Lordship.
Yes,
to Lordship.
liberty to file afresh.
I would like.
Lordship, interim, no, Lordship, if it interim was there, then it may be vacated, Lordship.
Oh, interim was there.
Lordship, we have to
If
go,
it's there,
to Lordship.
then
If it's there, then it may be vacated, Lordship.
Just give me that record. Item 12.
Automatically.
Oh, they have taken it.
Lordship, if there is interim, it may.
Yes, yes,
It may be.
automatically since it's withdrawn. We'll see
Order may
later.
be-
Wait.
Order may be reflected, it interim is there, it may be vacated. Lordship.
I'll check the records and
Yes,
then I'll put it in.
Yes, Lordship.
Obliged.
Lordship, here in the present case, Your Lordship, service report still awaiting, Your Lordship. To the sole
Service
respondent.
report not yet received, yes.
So, the matter may be listed after 3 weeks in the meantime.
Office note dated 2/4/25 indicates that service report on the sole respondent is yet to be received. Learned counsel for the appellant is present. Stop. This is the matter after 3 weeks.
3 weeks, Your
After
Lordship.
3 weeks, awaiting the service report on the sole respondent.
Lordship, there is an interim order till
The
then.
interim order passed earlier shall continue till the next date.
Lordship, we have checked the order, Lordship. There's no interim.
Okay.
Yes, Lordship.
Lordship, it's a criminal appeal against the conviction under POCSO Act. So now, on the earlier occasion also, Your Lordship, the court has directed to implead the informant.
It has not been served on the victim slash informant. Accordingly, the registry is directed to serve extra copy of the appeal memo to the learned PP in order to enable him to serve notice on the victim slash informant through the concerned PS. And also enclose the information that that the informant slash victim is entitled to legal aid counsel if so advised. Stop. List after 3 weeks.
3 weeks.
After 3 weeks.
Obliged.
May I please, Your Honor? Your Honor, inadvertently, my lord, step has been not
You have
taken.
not taken steps.
Yes, my lord.
What happened last time also, you
Yes, my lord.
were supposed to take first steps. Learned counsel for the petitioner submits that he is yet to take fresh steps for notice upon the sole respondent. Stop. Accordingly, the petitioner is allowed how much time?
My lord,
Now,
by tomorrow, my lord, I will take.
accordingly, the petitioner submits that he will take first steps by tomorrow. The prayer is allowed, list the matter after 3 weeks.
Yes, my lord. My lord, interim is there, right? Maybe kindly continue.
Interim order passed earlier shall continue till the next date.
Deeply obliged.
May I please, Your Lordship? Your Lordship, I beg to pray for allowing us.
Definitely losses. This is, we are challenging the reference order. The order is passed by reference authority. In fact, last,
You know, I beg to pray for allowing us at least for this
Government
time.
advocate.
Yes, Your Lordship. For filing our counter affidavit, Your Lordship. We are yet to receive our instructions, Your Lordship.
On 21/2 also same prayer was made.
But I'm hearing for the respondent number 2.
Respondent number 2.
Report. We have received the notice and accordingly, my lord, we appeared on 3rd of March. My lord, we also want a time to file a reply to my lord.
Okay, so together we'll give you 3 weeks.
My lord, let it be 7th of May, let it be 3 weeks time to granted, and in the meantime, it may be fixed to
7th of May.
7th of May.
Learned government advocate, MS K. Wangmo. Okay. P. Sankita appears for the government for the state respondent. One, two.
Only one.
only one.
Respondent number 1. Please.
Kamal Agarwal, K. Agarwal.
Appearing for the
Respondent number 2.
the respondent number 2 has prayed for time to file a counter affidavit. The learned government advocate also prays for some time to file the affidavit in opposition. Stop. Learned counsel for the appellant is present. For the petitioner is present. Stop. Prayer of the respondents is allowed. At least the matter on
7th of
7th May.
Your Lordship, it may
25.
come as an admission matter. Because otherwise,
Otherwise, it's for orders.
yes, it is for orders.
The
So,
order list, or
so-
in the order
so-
column.
No, let the pleadings be completed and thereafter matter will be listed for admission, my lord.
no, in fact,
Let the pleadings be complete first, na? Let the
no, in
pleadings be
fact, we are challenging the order passed by reference authority. So not much, I think, plea is not required. I think it can be decided on.
But
Anyway.
we don't know what will come.
Yes.
My lord,
No
it,
issue.
it will need some time to, my lord, go through, my lord. The lordship will kindly recollect the earlier case has a connection with this.
Acha, acha, acha.
And why I'm saying,
Okay,
because
that's
they were
why-
earlier the party to the reference case,
Ah.
but they withdrew from there without taking a liberty. And thereafter, they filed the reference case, then the court says that no, since
So
they-
that's what, it has to be.
anyway, your lordship will hear the matter.
That's why 7th May you are
7th
saying,
May,
okay.
Rishi.
May come as the admission matter. It can be disposed, your lawsuit can dispose on that.
Also, we can dispose, any
Yes.
stage we can dispose.
Yes. That's okay then.
You want for admission on that day?
Release the matter on 7th May. In the meantime, the learned counsels for the respondents may file their affidavit in oppositions.
Obliged.
My lordship, matter in practice, lordship, I may be allowed to withdraw the matter.
Withdraw.
Lordship. It's in practice, lordship.
At the outset, learned counsel for the petitioner states that the matter has become infructuous and he may be allowed to withdraw the petition. Stop. Learned counsel for learned PP is present. Prayer is allowed. The petition is disposed on
90.
withdrawal.
Well,
If there is any interim, then it may.
Any
take-
interim order
Yes,
shall
Lord.
stand vacated.
Much obliged, Lord.
I can.
No, they said there is no interim.
And that was not interim.
It was not there.
Obliged, lordship.
Obliged, Lord.
Disposed on withdrawal. Okay. What is SAO? Converted from RSA to SA. Anyone appearing for the parties? None. None appears for the parties when the matter is called. This is the matter of the treats. Because now behold, the government is coming in.
May please your notice. Notice, this is a second appeal. However, then counsel for the opposite party. He has informed me he's out of the station. He's going to send one, I am for the appeal. Okay.
Is
Send it to
someone
me or what?
mentioning, let someone mention for the respondent. No one.
So anyway, maybe,
Substantial
some other
question of law framed.
Fixed item so that they may not be remained.
Yes,
Absent.
yes, yes. Learned counsel, you are for,
M
you are,
part.
M part appears for the petitioner, for the appellant. None appears for the respondent on call. It is stated that the counsel for the respondent is out of station today. Accordingly, this is the matter on
6th of May.
6th of May.
Yes.
2025 for hearing.
Obliged.
Lordship, kindly the matter may be adjourned for today.
For the day.
Adjourn for, after 2
Let
weeks.
it be after puja break, your lordship. Since
After Bihu break.
Break.
there is a been interim also, your lordship, so no issue.
On the prayer of the parties, let the matter be listed after Bihu break for hearing.
Interim may be continuing.
Interim order passed earlier shall continue till the next date.
Deeply obliged.
Let's hear something at least.
May I please, my lord? My lord, this morning I filed an additional affidavit. So I wondered whether it is placed on the record or not.
My lord, I'm appearing for the respondent number 2 and 3, my lord. I have not received a copy of the additional affidavit yet, my lord.
Yes, my lord, because the
Additional
council is on
affidavit.
Guwahati, so I could not provide him the additional.
Send it by email, scan copy.
My lord, my
You have a
learned
local
brother is
counsel
a
there.
local counsel also.
Oh,
I will provide the same during the course of the day.
In
you
fact,
are.
my lord, this case has been charge sheeted.
Yes, that is why that additional
That is
affidavit.
why they are
Yes, ma'am.
challenging the charge sheet also. Where is your, that will be additional affidavit of petitioner. It does not
Yes.
come on record, I think.
Yes, my lord.
My lord, learned PPS received the additional
We
affidavit.
also received today morning.
Only I think due
No,
to
no,
the
but if you filed it this morning, then it do not come on
Yes.
record. No?
My lord, it must be with the registry.
It's okay since they have not received also, no? It is stated that the petitioner has filed the additional affidavit this morning. And learned PP has obtained a copy of the same. However, learned counsel for respondent number
2 and 3, my lord.
2 and 3 is yet to receive a copy of the additional affidavit. Accordingly, the learned counsel for the petitioner shall supply copies of the same on the respondent 2 and 3 within
During the course of the day, if they are available.
during the to the local council, okay?
Yes.
They will be supplied to the local council during the course of the day. And list the matter
8th of May.
8th of May.
Yes.
Even we will
8th
get
of
time to
May.
file a-
On
Much
8th of
obliged,
May-
ma'am.
8th of May for hearing.
Much obliged.
For admission hearing. Highly obliged, my lord.